Good morning. My name is Edward Farrell, and I'm an attorney at Cummins White. Today I will be giving a PowerPoint presentation on construction contracts. This is a two-part series. Part one, which we will discuss today, will be on contract documents and flow-down provisions. So a little bit about myself. I have about 10 years of experience in business litigation and trial advocacy, specializing in construction disputes. And my practice focuses on civil litigation and commercial and business disputes in real estate and construction law. Here at Cummins White, we are located in Newport Beach and primarily represent subcontractors and material suppliers in both private and public works of improvement. However, our firm has a variety of practices and practices all facets of law and can assist clients in corporate, real estate, estate planning, litigation, and trial work. So, overview of the presentation that we're going to talk about today. Here we're going to be focusing on construction contracting, which is really going to help subcontractors who are negotiating and understanding contracts on both residential and commercial works of improvement. The flow of the presentation will first discuss what a contract is. What are the contract documents outside of a subcontract which apply to a subcontractor's scope and provide additional duties and obligations? What are common and mostly used flow-down provisions, which are terms and conditions in a subcontract which apply to the subcontractor, also present in the prime agreement between an owner and a general contractor? Finally, we will discuss some tips and helpful points for a subcontractor negotiating and entering into a construction subcontract. So starting off with what a contract is and what it means for a subcontractor. It is the primary document that sets forth the legal relationship between the parties to a contract. It is the focal point for a subcontractor in addressing and completing his scope of work on any work of improvement. Contracts can come in all different forms and lengths. They can be standard agreements or customized to the unique project and scope of work for the subcontractor. Many of our clients find that when they work with large general contractors, these general contractors will have standard form agreements which have the same terms and conditions or boilerplate language that they provide to all material suppliers and subcontractors on a large work of improvement. The contract will set forth the terms and conditions, duties, and obligations for a subcontractor. These will define the parties' risks, rights, and duties. Also, the contract will put forward the process and procedures by which dispute resolutions can be achieved on any project. This would include disputes that arise between the subcontractor and the general, or any disputes that arise between an owner and a subcontractor. Let's talk about some important steps that a subcontractor should follow when entering into a subcontract. First, it's critical for the subcontractor to read the contract before signing it. As mentioned previously, these contracts can come in many different forms and lengths, and the number of terms and conditions can vary. However, it's important for all these terms to be addressed, read, and understood prior to moving forward in the contracting process. Standard form contracts especially require modification to identify or acknowledge certain facts. For instance, any time constraints to a scope of work or any special situations on a project. These modifications can also address special circumstances. For instance, any restrictions on subcontracting or materials. Modifications should also address any legal issues on a project. For example, limitation on liability or waiver of damages taken on by a subcontractor. Again, modifications should be understood and proposed if necessary to preserve the subcontractor's rights. Modifications that are proposed are discussed during a negotiation process with the general contractor. The sub should propose those modifications and be prepared for the typical give and take during negotiations to make sure that its concerns are addressed in the subcontract language. Periodic and thorough review of subcontract documents is a good thing to do throughout the project and even post-project time. When the scope of work is completed, contract terms should be reviewed by a subcontractor if questions arise regarding warranties or retention payments. Now that we know what a contract is, let's have a little discussion about what are contract documents and what are the flow-down provisions that apply to a subcontractor based on a prime agreement between the owner and general contractor. Flow-down provisions start with the prime contract between the owner and the general contractor. This agreement will set forward all obligations and duties and requirements of the project from the general, and include detailed scheduling and payment requirements that the general contractor is to abide by throughout the life of the project. The prime contract will also have any restrictions for subcontracting and for material suppliers that the general may subsequently go out and attempt before the contract work begins. Quite simply, flow-down provisions are those terms and conditions in the subcontract which will apply certain terms and conditions in the prime contract to the subcontract. In other words, it passes down certain obligations in the prime contract to the subcontract. Flow-down provisions are a common use in the construction industry. So the first question is, why are they so common and what are they used for? General contractors will include these flow-down provisions as a primary measure to limit their own exposure. By putting subcontractors in the same position as the prime, general contractors are making sure that their same obligations to the owner are respected and applied to both the subcontractors and their work. Flow-down provisions also allow the general contractor to apply a consistency of obligations and requirements on all subs and material suppliers on a work of improvement. Therefore, there's no misunderstanding as to obligations which apply to some trades, but not others. Some of these obligations would include scheduling, time extensions, the change order process. Again, these would be certain provisions which the owner is intimately involved and mostly concerned. These would be the most critical aspects of a prime agreement which flow down to the subs. The common use of flow-down provisions make it critical for subcontractors to go outside just the four corners of their own subcontract to understand the universal application of their obligations on a project. They must have access to and understand the prime agreement and the obligations on the general contractor in order to understand its requirements under flow-down provisions. Let's talk about contract documents and what these documents are and how they apply to the obligations of a subcontractor. Contract documents provide additional obligations regarding the rights, duties, and allocations of risks between the general contractor and a subcontractor. These contract documents are defined as a number of documents and drawings collectively referred to outside of the subcontract, but pertinent to the scope of work and to the work of improvement. The contract documents are connected and cross-referenced to one another so that they collectively form a single contract between the parties. Knowing what these contract documents are important, that they apply to the subcontractor, and they are crucial for an understanding of the subcontractor's work, let's discuss some common contract documents that we see. Especially in the public works atmosphere, bidding documents, including invitations to bid and requests for proposals, are contract documents that can be included and applied to a subcontractor. Drawings by architects or other design professionals also can provide an additional scope of work or understanding as to how specific subcontractor trades are applied. Additional specifications by design professionals may also be included as contract documents. Modifications to any of the above documents may also be included as a contract document that must be referred to by a subcontractor engaging in the contract negotiation process. Now let's look at a common subcontract clause that includes both flow-down provisions and a listing of the contract documents that apply to a subcontractor. So you'll see from the first part of this clause, there's an understanding of what constitutes the main contract. The main contract is both the prime agreement between the owner and the contractor, and is in accordance with the drawings and contract specifications and addenda. The clause specifically makes these other documents collectively referred to as the main contract. Finally, the last part of this clause specifically includes a flow-down provision, which incorporates by reference and makes a part of the subcontract the contract documents and main contract included above. Again, this is a very classic and common example of a term and condition in a subcontract, which includes both contract documents and flow-down provision. Let's look at another subcontract term and condition that may be included in a subcontract, which outlines and identifies contract documents. Again, here, more explicitly, we have a listing of what are constituting the contract documents. They include also the agreement, but the prime contract between the owner and the general contractor, outside contract documents, including drawings, specifications, and addenda, and finally, modifications. The last part of this paragraph includes that these forms are included and are a final part of the subcontract. Another popular clause that we see in a lot of these subcontracts are called integration clauses. These integration clauses provide that all of these contracts and agreements are a final integrated agreement and supersede any prior negotiations or agreements between the parties. Here in the yellow box, we see an example of a very commonly used integration clauses, showing that it is the final representation between the parties and consists of all obligations and duties of the parties going forward on the work of improvement. Some of the points that we can take away from today's presentation. First, it's important for a subcontractor entering into the negotiation process for a subcontract to pay attention to detail, both as to all terms and conditions in the proposed subcontract, flow-down provisions from the prime agreement, and any outside reference contract documents which are included and present additional duties and obligations on the subcontractor going forward. Both flow-down provisions and contract document definitions require the subcontractor to review additional documents, including the prime agreement and general and special conditions between the owner and prime contractor. Again, because of flow-down provisions, these conditions may be applicable to the subcontractor. Finally, it's imperative for subcontractors to obtain all listed and understood contract documents. These are contract documents that lie outside the subcontract, but are just as important and apply to the subcontractor. Therefore, the subcontractor must get access to and review these documents to fully understand what they must do going forward to comply. You may have questions or issues arising after this presentation today. If you do have questions, please feel free to contact me by either an email or you can contact me at the phone number posted. Thank you for your time.